Okay, we're back on the record in the Rehman Smith matter.
Thank you for the bench conference, Your Honor. I have an advice of rights form and plea form signed. The plea form does have the sentencing judge waiver box checked, but my understanding is we'd be asking for him to be sentenced today.
Okay. And I have no objection to immediately sentencing him. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Nothing but the truth.
State your name, please.
Chestnut.
Okay. This court's understanding, Mr. Smith, you're going to be pleading guilty to the charge of false pretenses 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that could be the maximum fine. You understand that? And upon your plea to that charge, that count 3, counts 1 and 2 would be dismissed. Do you understand that, sir? All right. So understanding all of that, do you still wish to plead guilty to that charge? How do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Remember, we went over those rights?
Yes, ma'am.
You understand you're giving up those rights?
Sir.
All right. Are you on probation?
No.
Are you on parole? Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
Mhm.
You're doing this voluntarily and of your own free will,
Sir.
and because you believe that you're guilty of this offense?
Yes.
Pardon?
Yes.
Okay. October 17, 2023, at the location of 102 Middle Drive, Ypsilanti City, Washington County, State of Michigan. Do you know what you did on that date to make you believe you're guilty of this?
I probably had a credit card and a wallet. I shot old credit card and a dude probably had
You got
I
to
was-
say that to me again. You found a credit card.
yeah.
Do you mind if I have here?
Absolutely. Go on.
On October 17th, 2023, did you take somebody else's wallet?
I think I did. I think either I can't really remember. I just remember being arrested for something around work, and I don't know what Middle Drive is at, but I think it's by Forest.
Do you remember in Ypsilanti, you had somebody else's wallet and attempting to use their credit cards?
Yes.
You remember doing that?
Yes.
And you knew it was somebody else's credit card?
Yes.
You knew you didn't have permission to do that?
Yes.
And you presented it at the store as your own?
Yes.
All right. And you're either you attempted or you did receive goods or services in an excess amount of $200.
No, I did. I did. I didn't get anything. $200. The weekend I did it to be something else.
Okay, here's the way I'll do it. I would accept his plea to this charge, understanding that he's actually admitted to the higher charge of the possession. All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
But Judge Simpson, I think, can you send it to the higher charge, to the higher courts?
Pardon?
It's just a misdemeanor charge. He's using what you admitted, which constitutes facts of the higher charge, but right now you're just entering a plea to the misdemeanor.
I'm just going to accept your plea to the misdemeanor,
Oh,
like you wanted me to do at the beginning.
do I go to the higher courts?
Pardon?
I go to the higher courts.
You go to the higher courts?
Like downtown. Arbor?
Not for this.
No, not for this one.
All right,
In fact, we're gonna, in a very few moments, we're gonna be done with this case entirely.
thank you.
You're welcome. All right. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Is there anything you'd like to say before I do impose sentence on this case?
Don't have to say.
No, thank you.
Sent to the court, the state minimums of $125 will be imposed, although they're 365 days in jail. Credit 365 days served. All right. Smith, you're all set.
Mr. Simpson.
You're welcome. Take care of yourself, pal.
Thank you, Your Honor.
All right. Court's going to stand in brief recess.
All rise.
Joy Gaines, Senior Assistant Defendant, and on his other matters, all his other.
All right. And what are we doing?
Your Honor, for 3 of the cases, we have both parties have agreed on a referral to mental health court. So for those 3, we're seeking a short adjournment to make that happen, hopefully.
And what about the other one?
That is correct, Your Honor. We're also seeking mental health court on that matter as well.
So we're mental health court on all of the cases.
That's not entirely true, Your Honor.
Pardon?
That's not entirely true, Your Honor.
Okay.
Case that I know, we haven't discussed a referral to mental health court on that matter.
Which one's that?
That
That's the CSC one.
Oh, Your Honor, that's the CSC one.
That's the CSC 4.
is, would you like the number?
Yeah, Your Honor, we are hoping that hopefully everything resolves together. At this point.
Okay, so what do you want me what do you want me to do?
Your Honor, I believe
Same
we're asking
adjournment.
for an adjournment for those matters so that we can do the mental health court referral. I'm standing.
Okay, but in the other case,
We'd
an
like to-
adjournment, are you going to have an objection to an adjournment so they all track?
No,
How long an adjournment do you need for the mental health referral?
3 weeks, please.
Conference in these matters will be adjourned March 26, 2026, 9 a.m. Bond will continue in all cases.
Your Honor, could we address bond as well, please?
Sure.
To be perfectly candid, things didn't go so well for Mr. Ikeji last time he was released, but the difference now is that he is on his medication. It's been going really well. He has, he's been in touch with folks at community mental health and jail social worker. He has parental support. Mom and his dad are here. He'd be able to live with them. And because of how well he's responded to medication, that he's on his way to mental health court, our request is that you release him untethered to continue. The other piece is he has been in now for 4 months since he was arrested on the case that I'm representing him on. And so we're sort of approaching a similar amount of time to if he were convicted there as well. Thanks for considering.
Your Honor, those were the same exact arguments I was going to make in terms of bond, but really stressing what a different place he is in right now. He this is the first time he's been able to appear in court. He is significantly more stable. In addition, he's a college graduate, so he has, as he continues in his recovery, he has opportunities for employment, and he does have strong family support.
Response from the people.
Your Honor, I would defer to the court on this one. I would, however, like to raise concern that, of course, he was released at one point and it's now back before Your Honor. Back in jail, of course. So I would raise that, maybe we're in a place where we want to refer to mental court. Maybe it might be best to wait those 3 weeks to see until that happens. I understand that he's in a better place, but we're still, of course, referring him to mental health court rather for a reason. So maybe it might be best to just wait that period.
And I think that's what I'm going to do. I'm going to let that referral and that assessment go through. And then I don't mind taking a look at it again, but he didn't do well when he was out before. So I'd wait to whatever assessments or anything else I can look at it and see prior to making a ruling that he would be released. I would be more than happy to look at, but I'm not going to do that without it. Absolutely seeing. All right.
Thank you, Your Honor.
Thank
Thank
you.
you. Court does call the case People versus Erica Chimente. Does call the case, People versus Larry. Is it Carsora?
Judge,
Alan Chadwick, the people here.
Marshal, Mr. Assistant Public Defender, on behalf of Mr. Larry Kosaru.
Carsora.
Mr. Kosaru, please ask the jail to unmute you and then state your name for the record. Judge.
You may.
Hello,
Hello, state your name, sir.
Larry Kazaru Jr.
Close. Thank you, Judge. Notes in my file indicate that we did just receive some additional media discoveries from Mr. Kazaru. I'd be asking for an adjournment to review that with him.
All right, you want the 19th or 26th?
The 19th is fine, Judge.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you. Thank you, sir.
Thank you.
Court calls the case, People versus Thurman Pool.
Morning, Your Honor. Raymond Cook for the people.
That is correct.
Good morning, Kareem Johnson, on behalf of Mr. Poole. This is the co-defendant case, Your Honor.
Yes. And
He's gonna be.
the next in. Your name, sir? Thurman Pool. All right. What are we doing on this?
Your Honor, we're setting this for exam, and I would like to address my client's bond.
On the, who has the co-defendant?
Mr. Burgess,
Is that going to be the same position on?
Setting it for exam, Your Honor?
Yes.
That's correct.
All right. And Mr. Johnson, you're not available the 17th.
That's correct, Your Honor.
All right. So I think I said his other matter for the 31st when we looked at dates. Will that work for you, Mr. Burgess?
That's fine.
Is that okay? So who's, what are the numbers?
I updated your shift for the 31st. You've got to Washington.
Well, we'll just start loading her up at some point. I'll set preliminary examination in person March 31st, 2026, 9 a.m. before Judge Washington. All right, as to bond.
Your Honor, my client does have significant family support. His mother, his brother have been in constant contact with me. He does have a place to go and responsible people to make sure he will abide by any bond conditions. We concede that allegations made in this case are serious. However, I don't believe, other than a picture taken over an hour after the incident, there's no electronic, scientific, or personal identification that places my client at the scene of this crime, conducting any crimes, Your Honor. So because of that, we'd ask for a significant bond reduction to $15,000 cash, surety of 10%.
People would object to any change of bond at this time. The basic allegations here is that the defendant, along with the co-defendant, fired at an occupied house. My understanding is that that house had previously been occupied or owned by members of a rival gang, and that this was a gang-related shooting. The members or the individuals in that house were not really with that gang, completely innocent, is my understanding. But the defendant, the co-defendant, fired, I believe it was 25 rounds into or at that building, including some of those rounds being fired by a fully automatic weapon, some of those rounds being fired by a rifle. I have significant concerns for public safety. If the defendant is to be released now, I'd ask that bond remain as set.
I guess the only concern that I had is Mr. Johnson indicated there is evidence that connects this defendant to this crime, I'm presuming.
Yes, it's a lengthy report. I can go through and try and find exactly what evidence that is, but I can have just a second.
Well, that's okay. It's just, it made it sound as though there's no evidence that connects this individual, but that's not what the people's position is.
Correct.
At this point, given that exam would be pending, I'm going to deny the request for a change in bond. Bond will continue. All right.
Yes, sir, Your Honor.
Thank you. Thank you. Court calls case People versus Willy Collins.
Morning, Your Honor. Raymond Cook for the people.
Hearing on behalf of Mr. Collins, Your Honor. Did you get my green sheet?
I did.
So we're requesting an adjournment.
That's to go. I've got it. I have a violation, however.
Yes, I shared it with him.
How come he hasn't gone?
Your Honor, there was some miscommunication when he was released. And he has a plan now. He lives on Berkshire. He has a plan so that he can, and he'd be clean today if we were to test him.
But he hasn't been over to test.
Well, he knows where it is now.
But he didn't know before?
No. He just said he didn't know where it was, Your Honor.
Well, why didn't he find out?
Well, be careful what you say.
I mean, he hasn't tested at all.
Well, he'd be clean right now,
Well,
today.
but he hasn't tested at all while he's been on release.
That was from what, the 24th, so it's not like it's a couple months.
So he just didn't go.
Well, he didn't know. That's my information,
He didn't know what.
that he was supposed to go. Well, be careful what you say.
Your Honor, when I was talked to by the magistrate, I just got Jackson County doing a year. I'm on probation in Jackson County. So the magistrate told me that I can test when I go report. I just reported Monday.
He told you what?
That I had to reply with Jackson County's probation.
Comply with Jackson County probation. He means, I think he has tests as a condition of his probation in Jackson County. So Jackson County,
I don't have any record of that. None is written over.
that's what he's representing, his information and belief when he was arraigned, that he could substitute the testing in Jackson County here. That's all. There was a little miscommunication on his part. So
But he hasn't. Have you tested in Jackson?
Yes, sir. I just
When?
Monday.
When?
Monday, sir.
he'll sign a release right now if you want.
Well, he needs to get over there and do all of that, but I'm not gonna have a circumstance where we tell him to test and he hasn't even gone over there and reported.
But he's testing at
He
another.
hasn't reported and hasn't been in contact with our community correction.
Well, he's prepared to do it right now. He's just being double dipped, testing two places, that's all. And it's not your fault.
Oh, I know it's not my fault.
It's not your fault. Quit laughing.
March 26, 2000, I'll set his adjourned probable cause to March 12, 2026 at 9 a.m. But at this point, defendant's bond is revoked. Defendant remanded.